Number 155, Clarence Earl Gideon Petitioner versus H.G. Cochran.
We'll hear argument first this morning in number 86-1278, Hustler Magazine and Larry C. Flint versus Jerry Falwell.
The issue before the court is the admission in evidence of the defendant's confession.
The standard of review is de novo, by which I mean it respects the jury's findings of historical fact.
Goldberg's gone. I'm sorry about that, Ruth.
Welcome to another episode of De Novo, a Supreme Court podcast. This ruling really didn't come as a surprise to anybody. I think we knew exactly how this was going to turn out based on oral argument. I think that the really surprising aspect of this, though, is the consensus on all of the nuanced issues that are surrounding this case and really the highly polarized political posture that this case took. Of course, we're talking about Trump v. Anderson, a case that was heard by the Supreme Court and decided today, March 4th, 2024. Just for those who are not familiar with Trump v. Anderson or have not opened up any news today or since, the Supreme Court decided to hear Donald Trump's case on an expedited basis. A group of so-called Republican voters challenged the Secretary of State in Colorado, arguing that Trump should be taken off the ballot because he committed insurrection, and as a result of Section 3 of the Constitution, he should be prevented from holding office. That section specifically discusses those who have committed insurrection and would seek to prevent them from holding public office in the future. Obviously, that came out of Civil War era requirements. So the Supreme Court heard the case. They heard oral argument, and during oral argument, we heard some fire from Justice Jackson, but for the most part, a lot of skepticism from the court. Brett Kavanaugh spoke up significantly on certain issues. And there were a lot of fantastic questions raised from the bench. It seemed like even Justice Sotomayor was against this idea. And, the reason is pretty clear. If the court decides this case, this type of issue in favor of these voters in Colorado, this decision would apply to anybody else seeking public office. And what we would essentially have is a state-by-state battle based on qualifications, where presidents would have to sue, potential presidents, candidates would have to sue to get a particular result after a state sought to exclude them. Perhaps President Obama, some state might have made some wacky decision that he was not a citizen and should be excluded. There was that theory floating around. Perhaps Biden, they may argue that perhaps he should be excluded for one reason or another. It doesn't necessarily have to be true. It just needs to have somebody sue on the issue, and it has to be decided by a court. That creates a bit of a mess. And I think the federal government has a lot of interest in controlling who can appear on a ballot, and states should not interfere with that. That is what the Supreme Court decided 9-0 on March 4th, 2024. So let's go into a bit of the background and the basis of this decision. So first, we've got a group of Colorado voters. They're arguing that Section 3 of the 14th Amendment to the Constitution would prohibit Donald Trump, obviously running for the presidential nomination of the Republican Party, seek to prevent him from appearing on the ballot. This case filtered up from the trial court, where a 5-day hearing was held. And largely with that hearing, what we saw was the January 6th committee findings were introduced into evidence over the hearsay objection of Donald Trump's counsel. And that was one of the striking issue that I spoke about previously on the podcast. This hearing was a 5-day hearing in which hearsay was introduced, and it wasn't really a full adversarial proceeding as we would consider under the Due Process Clause. And when we're dealing with taking away the rights of potentially millions of Colorado voters based on a 5-day hearing where hearsay is allowed and there's no real due process provided, that's a very problematic thing. And obviously the Supreme Court picked up on that. So, the case originally started in last September, and it took this amount of time to to get up to the Supreme Court. Let's go over Section 3 specifically. This is cited in the opinion. For those who don't know the actual text of this is very important. It says, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. But Congress may, by a vote of 2/3 of each house, remove such a disability. One of the things that was argued significantly, and I don't want to get ahead of myself, it was this vote of 2/3 by Congress. The issue in reading this, the way that these Colorado voters wanted us to read it, is that it immediately disqualifies and you shouldn't appear on the ballot. But the reality is that Congress could, by 2/3 vote later on, after the person is elected, remove the disqualification because perhaps they believe that there wasn't really an insurrection. So if you have a state making this decision and keeping somebody off the ballot, you're really preventing Congress from doing their job and engaging in the vote and the decision making the way that they want to. And this was fundamental in the holding of the Supreme Court here. So we have that section in the Constitution. We've got the 5-day trial where eventually the Colorado Supreme Court determined that Donald Trump had engaged in insurrection. Now, this is where we have to stop for a second. The Colorado Supreme Court determined insurrection, which is kind of surprising because Jack Smith, the prosecutor who fully investigated this, did not charge Donald Trump with insurrection, probably because at best he would have an attempt. And this section of the Constitution, it says nothing about attempted insurrection. It says insurrection. The other issue is that, they really couldn't tie the statements made by Donald Trump to the conduct of the people. There was no specific direction to go and, invade the Capitol building that day. And so from a conspiracy standpoint, we really don't have enough. Despite that, Colorado was making the decision on their own. And regardless of who's right or wrong, the issue here for the Supreme Court is the inconsistency in the position taken. The federal government is not alleging insurrection. Colorado is suggesting insurrection. Who really gets to decide for the United States? And the Supreme Court very clearly in this decision said, no, it is absolutely Congress that gets to decide. Now, there was consensus. This was a 9-0 opinion. But we do have a couple of justices who wrote separately, as you would expect they would, because they felt that the Supreme Court went too far. I'm going to get into that towards the end of this. But it's really important to note that when I say consensus, it wasn't, officially a full-throated consensus by all sides where everybody was happy and backslapping about the decision made. There was some departure, but there was no departure on the ultimate decision, the decision that a state cannot decide who goes on the ballot on its own. Now, of course, this could cause constitutional concerns for a lot of provisions that are in state constitutions and in state statutes, which would give a Secretary of State authority for what's on a ballot. So those things need to be looked at. Now, how specifically did the Supreme Court get to this decision? That's what we really need to look at. First, they framed the question. This case raises the question whether the states, in addition to Congress, may also enforce Section 3. Limited question. Do states have rights to enforce Section 3? Supreme Court clearly states, we conclude that states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. What does that mean? That means that states can only control who is on the state ballot as a state representative, not any federal office. President, vice president, member of Congress, senator, states have absolutely no right to exclude that. The court goes through a pretty nice analysis about how we get there. First, they start with some prior precedent, Bond v. United States, that very clearly indicated in our federal system, the national government poses only limited powers. The states and the people retain the remainder. So we start with the presumption, and the conservative justices would have really wanted this case in here, that the federal government doesn't have all the power. They have some of the power. In fact, the federal government only has the power that is specifically reserved for itself. The states have everything else. But then they go on to say that this is one of those powers that the federal government has specifically reserved for itself. They go through state powers just to make it clear that this isn't an anti-state decision. In particular, states enjoy sovereign power to prescribe the qualifications of their own officers. They have that right. They further note, although the 14th Amendment restricts state power, nothing in it plainly withdraws from the state this traditional authority. That's a very interesting fact here. But they further note, such power over governance does not extend to federal office holders and candidates. Here's why. The Supreme Court says this very clearly. Because federal officers owe their existence and functions to the united voice of the whole, not a portion of the people. The Supreme Court very clearly, and everybody agreed with this, all 9 justices in this part of the decision agreed with this. The United States as a whole gets to decide who's elected. So if you meet federal qualifications, you are on the ballot. That's it. Case closed. There will be no lawsuits to remove you, and no states get to decide. Well, then how do we keep people off of the ballot? Well, that is a power specifically elected and reserved by the federal government. There's a whole bunch of case law cited that really supports this conclusion, that there's no power delegated to the states that allows them to make decisions over federal office holders. In fact, they say that such a power would flout the principle that the Constitution guarantees the entire independence of the general government from any control by the respective states. One interesting thing that could come out of this case is a challenge to the Fani Willis and the New York indictments, Georgia and New York, under the basis that if there was any conviction and punishment that needed to be served by Donald Trump, a state should not be able to invoke that and prevent him from taking office because it usurps the will of the people as a whole. A jury of 12 and a judge of 1 should not be able to decide whether or not Donald Trump can take his office after the United States has spoken, if he happens to be elected and also if he happens to be convicted. The Supreme Court wants to stop needless fights in the future for both sides, and that's really what this decision means today. They do get a little snippy in their opinion, fighting back at how this decision came to be, the lower court decision. The first line here that I think is quite snippy. This can hardly come as a surprise, given that the substantive provisions of the amendment, the 14th Amendment, embody significant limitations on states' authority. In fact, later on in the opinion, they actually say, as an initial matter, not even the respondents contend that the Constitution authorizes states to somehow remove sitting federal office holders who may be violating Section 3. I mean, that's really where the Supreme Court gets the respondents, the Colorado voters in this case. When asked the question, do you think a state could file suit and remove somebody who's a current office holder on their own and actually rip them from Congress or rip them from the office of the presidency or rip them from some other federal office? Do you think that they could file a lawsuit against Mayorkas, who was recently the subject of impeachment proceedings, and say he's disqualified because he hasn't done his job? If that answer is yes, then that means the states have supreme power over the composition of the federal government and the officers inside of the federal government, which would absolutely be anarchy. And that's really where I get a little offended. This case never should have been before the Supreme Court. A 9-0 decision reversing the Colorado Supreme Court isn't even a close call. The Colorado Supreme Court owes a duty to fairly evaluate the laws of the United States, to fairly determine whether or not they have authority and jurisdiction under the Constitution. We all read that lengthy Colorado decision, and there were pundits out there supporting it and saying it was correct. There are people who've put their legal reputation on the line backing the Colorado Supreme Court. And to each and every one of those people, I would say, you just lost 9-0. You just found out that not even the most liberal justices on the court were willing to follow the flawed reasoning of a state court suggesting that it has the ability to interfere with the election. Those people who supported the Colorado decision support election interference in its most egregious form. This is worse than bringing people to the polls or voting twice. We've seen that in Chicago, obviously, alleged back in the day. This is much, much worse. This is suppressing the vote of tens of millions of citizens of Colorado, arguing that a state Supreme Court, a divided decision of a state Supreme Court, should have the ability to remove somebody from the ballot. Now, could Trump have still won without the electoral votes in Colorado? Yeah, he probably wasn't going to get them anyway. That's not a surprise, and that doesn't really matter. But immediately after Colorado acts, we see Illinois act. I believe we had Maine act. We have other states acting. And in future elections, we will have other states doing the same thing. We would have a society where states would have the ability to litigate whether or not somebody can be in federal office, which has never been permitted. And this just shows how far certain people will go to stretch logic, to stretch law, to stretch the Constitution in their favor, to say something that it does not actually say, and to try to keep people from voting. I said this in the first episode when I addressed this. At the end of the day, voters get to go to the voting booth. They get to fill in their bubble or punch their Chad or whatever they need to do to vote, and they get to decide whether or not somebody should be president. That is a power reserved to the people. And Colorado thinking that it can take that power itself is misguided, abusive, incorrect, incredibly flawed. Those justices on the Colorado Supreme Court that voted in this manner should be subject to impeachment and should be removed from office. That's how troubling this is. A 9-0 decision against Colorado. The flaws in the Colorado reasoning are pointed out by a unanimous number of justices from the court. Another attack on their logic. The justices say, nor have the respondents identified any tradition of state enforcement of Section 3 against federal office holders or candidates in the years following ratification of the 14th Amendment. What they are saying is, in history, this has never happened before. Then they say, such a lack of historical precedent is generally a telling indication of a severe constitutional problem with the asserted power. A severe constitutional problem. People aren't willing to even utilize this interpretation of the amendment. They say it's an especially telling sign here because, as noted, states did not disqualify persons from holding state offices following the ratification of the 14th Amendment. What they're saying is, after the 14th Amendment was ratified, no action was taken against those who were alleged to have engaged in insurrection as a result of the Civil War. They say the pattern of disqualification with respect to state but not federal offices provides persuasive evidence of a general understanding that the states lacked enforcement power with respect to the latter. The case that was cited here, U.S. term limits 514 U.S. at 826. Instead, they say, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders. Now, what does this look like? If Congress actually wants to prevent somebody from being president of the United States, what would they do? They would do the same thing that they do with respect to impeachment. The same thing. Somebody gets on the ballot. They have the signatures. They have the qualifications. They get on a state ballot. State puts them on there. Everybody votes. We have the electoral college. President now is between the vote and the inauguration. Votes have been certified. We're waiting for inauguration. Congress gets together. Congress has a vote. By 2/3 of both chambers, if they vote that someone is disqualified due to insurrection, they cannot take office. What do we do then? I imagine the vice president would become the president, because that is the second place will of the people. 2 people are on a ticket for a reason. And then perhaps that person would choose a running mate as a vice president of the United States. That's how that would look. And that is a very simple process. That's not difficult. The disqualification would look just like it would if somebody became ill or infirm or passed away before they could take office. It's a very non-controversial approach. And you're still respecting somewhat the will of the people, because the running mate, who would presumably have the qualifications and not be voted out, would then take office and be very close to the will of the people. The way that the voters in Colorado who sued wanted this suggests that it's not that process that should take hold. You should prevent somebody from appearing on the ticket because of a proceeding that happens in a single state, where facts are decided in a single state, whether or not those facts or those opinions are shared by the rest of the nation. This is so far from correct. It's silly that the Supreme Court even had to take its time with this issue. The Supreme Court basically speaks to what would happen if the Colorado Supreme Court got their way. The patchwork that would likely result from state enforcement would sever the direct link that the framers found so critical between the national government and the people of the United States as a whole. But in a presidential election, the impact of the votes cast in each state is affected by the votes cast, or in this case, the votes not allowed to be cast for various candidates of other states. An evolving electoral map could dramatically change the behavior of voters, parties, and the states across the country in different ways at different times. This disruption would be all the more acute and could nullify the votes of millions and change the election result. The Supreme Court of the United States is calling out the Colorado Supreme Court for election interference. The Supreme Court is very clearly saying that this Colorado decision, if left to stand, would interfere with the will of the people and cause election interference. The Supreme Court of the United States had to jump in and prevent rampant election interference in Colorado and several other states. This is the United States that we're living in. This is the departure of logic. And now we have Fani Willis facing her own problems in Fulton County, having perjured herself on the witness stand, lied about the beginning of a relationship, started a prosecution of a former president of the United States for election interference. And her first move in that direction was to hire her lover to represent her office and to accept a substantial financial compensation from the people of her county in exchange for battling Donald Trump in the courtroom. And when faced with this, she alleged that it was a racial attack. She went further to rush to the witness stand to testify falsely, only to be confronted with thousands of text messages between her and Nathan Wade that very clearly show that a relationship between the two predates involvement in this case, and the testimony on the witness stand was perjured. We have a judge in New York issuing a decision against Donald Trump for hundreds of millions of dollars in a judge-alone trial, arguing that he cannot get a loan to pay that judgment, which is kind of an excessive step, despite the fact that no creditor was defrauded, no payment was defaulted on, and there was no specific harm indicated to the people of New York as a result of the alleged misconduct. This is all very troubling. This is not Donald Trump being slippery. This is the nation readjusting after seeing some of the harms that politically motivated cases will cause. And concerned citizens, Supreme Court justices standing up and defending the future of our democracy from political attacks so that we can have a fair election process. Feel free to review the article on the website, ronaldwchapman.com. The opinion in Trump v. Anderson is included in that article, as well as a bit of a write-up if you'd prefer to read. Remember to purchase the book De Novo. Feel free to reach out, hit the link, purchase the book, Unraveling Federal Criminal Investigations. Lots of very interesting info going through historic Supreme Court cases related to government investigations. Received a lot of positive feedback from folks, non-lawyers, who really enjoyed seeing this side of the federal criminal justice system and understanding a bit more about some of the biggest cases that have faced our nation. Oklahoma City, the Rosenbergs. There's some information in there about detainee prosecutions in 9/11. Tons of information about cases. And feel free to click that subscribe button so that you can get future episodes of De Novo. Thanks for joining me for this special edition to go over Trump v. Anderson, recent Supreme Court decision overturning Colorado Supreme Court decision related to Trump appearing on the ballot. Fantastic decision to read. I hope you can digest it. Thanks for joining me. As always, you can find me over at my website, ronaldwchapman.com. There you can find articles related to all of